Holy guacamole, Judge Chhabria is not happy with the Boies Schiller plaintiffs right now. Yeah, this is over in Cadre v. Meta. And those of you who have been following it know what happened last time, but for those of you who need to be caught up, here's a review. Meta never once suggested it would assert a fair use defense to the uploading-based claims. That is an outright lie. Meta failed to mention, much less assert, a fair use defense. Meta's supplemental response now argues for the first time, lie, that uploading pirated copyrighted works to other data pirates is somehow fair use. Well, imagine that. Imagine someone saying that. Respectfully submitted, Jesse Panuccio, ambulance chaser for Boies Schiller. Plaintiff's letter is based on the false assertion that Meta never once suggested it would assert a fair use defense to the uploading-based claims, including after this court raised the issue with Meta last November. Within that same CMC statement, whether Meta's conduct constituted fair use, and stated that Meta has informed plaintiffs that it will be asserting a fair use defense. Plaintiffs' counsel specifically acknowledged Meta's claimed fair use defense. They acknowledged it. In short, plaintiffs' assertion that Meta never once suggested it would assert a fair use defense to the uploading-based claims is false. Meta's supplemental response explains how those claims, even if legally viable, would fail based on fair use. So then let's see what this Panuccio guy has to say about it, since they've caught him in an outright lie. Meta does not dispute that its amended interrogatory response raises, for the first time, new factual assertions, and Meta does not dispute that its amendment comes 15 months after plaintiffs moved to add uploading allegations. What you're talking about now is new allegations that you made that you can't show happened. You can't show that Meta uploaded a thing, and even if you could, it was de minimis and part of fair use. Really, I don't know what kind of person it takes to be a judge, to hear lawyers talking like this, and not just slap them upside the head for being squabbling children. Especially this Panuccio bastard, who just lied to the court again! We saw it! We read them! You heard it! Yeah, so they lied to the judge about it, and he is not happy. Oh my god, you know how in the past I've shown you the ways the judges can kind of show that they're not amused with your antics but still keep decorum and everything? I think Judge Chhabria is losing his decorum. So this is his order about their request to amend it yet again. For a fourth time, this will be the fifth complaint. I mean, spoiler alert, you can see it right there in the order. It's granting the motion, so they actually win, but this is not going to feel like a victory. Let's just go straight into what he says. It's almost always easy to decide a motion to amend a complaint. This one is quite difficult. The lawsuit was filed almost 3 years ago, and the named plaintiffs have already filed 4 versions of their complaint. Now they seek to file a 5th. They wish to add a claim for contributory infringement based on the allegation that when Meta was downloading copyrighted works using BitTorrent, it simultaneously uploaded those works. That's the whole seeding thing we've been talking about. And if you're sitting there going, wait a minute, Shane, didn't they do that over a year ago? Yeah, they did. Let's read about it. One reason this motion is so vexing is that the plaintiffs, oh my god, when they use words like vexing, judges don't use that word unless they're really feeling something, is that the plaintiffs could have added this claim the last time they sought to amend their complaint back in November 2024, roughly a year and a half ago. At the time, the plaintiffs moved to add a distribution claim, and that was what they were saying, is by seeding it, they were distributing it. In other words, plaintiffs now seek to add a new legal claim based on factual allegations they already added the last time around. So last time it was distribution, this time it's contributory infringement. Same act, same fact pattern, 2 different charges. The lawyers for the named plaintiffs have no excuse for neglecting to add a contributory infringement claim based on these allegations back in November 2024. But apparently it didn't dawn on them to do so until they saw a new but related lawsuit against Meta by Entrepreneur Media. What have I said? These people are basically cheating off each other's homework. It has further dawned on plaintiffs' counsel in this case that Meta might have a defense to the distribution claim that may not apply to the contributory infringement claim. Counsel's failure to think of this issue back in November 2024 is bad enough. What makes it worse is the excuse counsel offers for waiting until now. Plaintiffs' understanding of the nature of Meta's use of peer-to-peer file sharing has crystallized, whatever that means. While earlier evidence, produced months after the close of fact discovery, showed that Meta distributed pirated content to BitTorrent peers in 2024, Meta's newly produced evidence provides a level of detail that was previously missing in this case regarding Meta's uploading and distribution activity while torrenting the asserted works and many others. This is a bunch of double talk. If it were really true that counsel couldn't have added a contributory infringement claim in November 2024 because Meta had failed to produce the discovery necessary to support it, the same would be true of the distribution claim that counsel did add back then. Rather than blaming Meta for producing discovery late, the plaintiff's lawyers should have been candid with the court, explaining that they missed an issue in a case of first impression. Remember, this is like the OG anti-AI case. No one had ever filed a case like this before, so it's understandable that you're going to miss something here and there. Just admit it. Just be honest with the judge. And asking for permission to correct it, because doing so would serve the interests of the proposed class without interfering with the case schedule or otherwise unfairly prejudicing Meta. Counsel's lame excuse. That's not my commentary. It's written right there. The judge says that, not me. It's exactly what I would say, though. Counsel's lame excuse for failing to add the contributory infringement claim in November 2024 is part of an ongoing pattern. It appears that counsel's strategy throughout this litigation, and particularly since the Boies Schiller firm came in and took the lead, remember we talked about them last time, has been to distract from its own mistakes, and there have been many, by bashing Meta. Counsel invokes Meta's recent assertion of a fair use defense. Meta never once suggested it would assert a fair use defense to the distribution claims. Meta failed to mention, much less assert a fair use defense. In truth, Meta disclosed several months ago to plaintiffs' counsel and to the court that it was considering asserting a fair use defense based on its current understanding of the plaintiff's distribution allegations. Yeah, you bunch of liars! The issue of when Meta disclosed that it would assert a fair use defense to the distribution claim is irrelevant to whether the plaintiff should be allowed to add a contributory infringement claim, so there was no need for plaintiffs' counsel to complain about Meta's handling of this issue, much less to make false statements about it. But the lawyers for the plaintiffs, again, particularly the lawyers from Boies Schiller, seem unable to help themselves. They seem so intent on bashing Meta that they are unable to exercise proper judgment about how to represent the interests of their clients and the proposed class members. Wham! That is a big smack across the head. Unable to exercise proper judgment. Probably one of the worst things a judge can say about you. By now, the reader might be thinking, wait a minute, you started off saying the motion to amend the complaint was difficult. This seems like an easy deny to me. Gee, how did you know, Vince? How'd you know that's exactly what I was thinking? Denying the motion to add the contributory infringement claim could potentially harm the interests of the proposed class members, most of whom are not actually represented by Boies Schiller. They're just representing the named plaintiffs. There's everyone else in the class too. Meta agreed to structure the litigation so that cross motions for summary judgment as to the named plaintiffs would be adjudicated before class certification. This gave Meta the opportunity to defeat the lawsuit on summary judgment without having to expend considerable resources on class certification discovery. But it also meant that if Meta defeated the named plaintiffs at summary judgment, the ruling would not bind the proposed class members. On the flip side, it meant that if the named plaintiffs obtained summary judgment and subsequently obtained class certification, proposed class members would know when deciding whether to opt out of the class that they had essentially already won. This is a concept sometimes referred to as one-way intervention. Meta agreed to waive any objections related to the one-way intervention problem. It's worth recalling that there are at least 3 copyright claims an absent class member could assert against Meta. There's a direct infringement claim about copyrighted works for the purpose of training its AI models, call it a training claim. There's a direct infringement claim based on the alleged uploading of protected works using BitTorrent, a distribution claim, and a contributory infringement claim by uploading protected works onto the torrenting network. As to the first claim, the court ruled against the named plaintiffs at summary judgment, finding that they had failed to produce evidence that could counter Meta's fair use defense. And remember, this was that video I made where I kind of criticized Chhabria for trying to split the baby. It won because the named plaintiffs' counsel had not marshaled any meaningful evidence on the most important fair use factor, whether Meta's copying had harmed or was likely to harm the market for the plaintiff's works. And if you remember, this is where he went against Judge Alsop in Bart's v. Anthropic, which had said it was spectacularly transformative, and if it's transformative enough, the fourth factor doesn't apply. If it's so transformative that none of the expressive elements are left, nothing else matters, it's just fair use. So now we have this confusion here, which Judge Chhabria has because of the horrible Warhol decision that I've been over, and we were looking forward to having this go up to the Ninth Circuit and say, okay, which way is it? You got the Supreme Court saying one thing and the Supreme Court saying the other thing. Now a judge is saying one thing and a judge is saying the other thing. But then the Bart's plaintiffs came in with the settlement, so we're going to have to wait on that. In reality, as I have said many times, this is as fair use as you can get. If AI training isn't fair use, then nothing is. Fair use doesn't exist, and you can say goodbye to your free speech rights. Again, this is exactly what's at stake. As to the second claim, the parties have yet to file cross motions for summary judgment. If the court rules for the named plaintiffs, or if the court denies both sides' motions on the grounds that a genuine factual dispute exists, the named plaintiffs will move for class certification. Now imagine the following series of events. First, the court denies the motion to add the third claim, the contributory infringement claim. Second, the court rules on cross motions for summary judgment that the distribution claim must go to trial. Third, the court grants the named plaintiffs' motions for class certification on the distribution claim. And fourth, the jury rules in favor of Meta. There is a serious concern that the interests of the absent class members would be harmed through no fault of their own. There is a possibility that they would be precluded from bringing a contributory infringement claim in subsequent litigation. And of course, there's a good chance that absent class members would not be aware or sophisticated enough to understand that they'd be foreclosing the opportunity to bring a potentially stronger claim by not opting out. Accordingly, the failure of plaintiffs' counsel to appreciate the need to add a contributory infringement claim back in November 2024 could do serious harm to the proposed class members. This is one factor in favor of allowing the named plaintiffs to file yet another amended complaint. Regardless of who ultimately wins this case, it is in the interests of the proposed class members to have all available claims addressed in the litigation. Meta has requested that the schedule in this case be pushed back so that expert discovery can proceed on the same schedule as in the Entrepreneur Media case. That request is granted. And of course, in the Entrepreneur Media case, there is already a contributory infringement claim. Moreover, this court has already ruled that discovery in the two cases will be shared. The upshot is that, regardless of whether the plaintiffs are allowed to add the contributory infringement claim here, Meta will be required to litigate the contributory infringement claim and on the schedule that has already been set. Which means that plaintiffs' counsel has lucked into a situation, where Meta will not be meaningfully prejudiced by the failure to add a contributory infringement claim back in November 2024. For all these reasons, the plaintiff's motion to add a contributory infringement claim is reluctantly granted. Yeah, it's clear that if this weren't a class action, this would be a very different ruling. It's only because he doesn't want to screw over the class members that he's allowing this to happen. The plaintiff's related motion to open class discovery is denied. Plaintiffs' counsel already has enough to focus on. Wow. Yeah, I think they do. Class discovery will be opened if the named plaintiffs can get past summary judgment on the distribution and contributory infringement claims. He sounds a bit doubtful to me. But he allowed it. They can amend it. It is so ordered. March 25, 2026, Vince Chhabria. Yeah, they won, but I'll bet you they're not feeling like winners right now. Oh, man. And what's going to happen if they keep pissing off this judge, and if they keep making one false statement after another? Well, at the very least, it'll be good content for this channel anyway. Because again, they have to do that, because they have nothing and they know it. Even the judge seems kind of iffy that this is going to last past summary judgment. But we'll see how it goes, and I'll be here to cover it. So thank you so very much for watching. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate Dopagosity.tv. Keeps me doing this. Whether one-time donations or regular support, get these videos early and ad-free. Join in the live streams, AMAs, other benefits. So check those out. Thank you so very much for watching. Until next time, stay strong and be free.